case briefs, and so much more. LSData's got what you're looking for.
In the 1962 legal case Nash v. Kornblum, heard by the New York Court of Appeals, a fencing company and a summer camp found themselves at odds over a dispute involving the installation of a fence. The initial issue stemmed from the written contract detailing the project's scope, a proposal for hex netting around 3 tennis courts at the camp. Due to an agent's typing error, the contract contained an incorrect linear ground measurement. The matter at hand began on March 17, 1958, when Mr. Harkness from the fencing company discussed the estimate with the camp's officials. Initially, the proposition was for chain-link fences surrounding the courts, but to cut costs, Mr. Harkness cleverly suggested the use of hex netting. The estimates, despite the change in material, were outlined in 2 separate contract forms that were strikingly alike, aside from the type of fencing specified. After realizing the discrepancy, the fencing company sought to reform the contract and correct the misleading measurement. However, the lower court dismissed the plea, arguing there was no evidence of fraud. But here is where the New York Court of Appeals diverged. The court argued that the trial judge misconceived the doctrine of reformation, which provides a remedy to correct mutual mistakes in written contracts, even in the absence of fraud. The dismissal was ruled erroneous, and the fencing company's request for contract reformation, being equitable, was deemed valid. As a result, the case was sent back for further proceedings, this time to consider the fencing company's valid request for reformation in light of the court's judgment. The Nash v. Kornblum case marked an important turning point in understanding the application of the Reformation doctrine, especially when no fraud is involved.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.